Hello and welcome to this week's Facts Friday. And today I'm joined by Mailing McNabb, who's a partner in our family department. Mailing, it's a pleasure to have you on Fact Friday. And today you're talking about collaborative law. So I'll dive straight into the questions in our first question, which is what is collaborative law?
Well, can I just say I'm very excited to be here today. So thank you very much for giving me this opportunity. In answer to your question, so following on from last week's mediation summary, collaborative law is again part of the non-court process of resolving financial matters in divorce. Now, collaborative law is a very different and relatively new way of sorting out the legal and practical issues following relationship breakdown. It is a non-confrontational approach to resolving many issues that can arise when family relationships break down. Now, the more traditional route when couples separate is that they would each take advice from specialist family lawyers and try to reach an agreement on how to settle their differences. If or when they can't do this, it is often left down to the family court to decide. Now, court proceedings often leads to delay, uncertainty, and can increase costs quite substantially. Collaborative law can offer a better solution, in my view. Now, as to how it works, under the collaborative process, each person appoints their own collaboratively trained lawyer, and you and your respective lawyers all meet together to work things out face to face. Now, both parties will have their lawyer by their side throughout the process and will have their ongoing support and legal advice throughout. So, for instance, if one party has a question or a point to make during the meeting, this is raised, a discussion is had, and where appropriate, advice is given, and the parties move on. So, in my view, our clients should be provided with the best opportunity possible of achieving the best resolution for their family, and collaborative law provides the platform to do just that.
Fantastic. On to our second question, Mailing, which is what are the benefits of doing it this way?
Now, there are many key and immediate benefits, Michael. It keeps separation out of the court process, for one. It's often quicker because it's not given by the court's time frame, and that can often be very slow. So to a large extent, the process can be built around your family's individual timetable and priorities. Another reason is that it's cheaper than court proceedings, as matters are dealt with at meetings and not by a letter or a court, which as a result, costs are then controlled. It's very much family focused, as I previously said. It can address all issues, children, finance, divorce, those sort of things. You can talk things through face to face, and as the issues arise, it's dealt with rather than waiting on your correspondence from your lawyers. So things are very much dealt with a lot quicker in this way. And the final key benefit, I would say, is that your lawyer will be with you by your side at the meeting to assist as and when required. So again, there is no delay in dealing with tricky questions or difficult issues which could hamper progression being made.
Excellent. Our third question today for you, Mailing, is what if I want to discuss my case with my lawyer in private?
Okay, well, you can do that. The collaborative process is open and transparent. So therefore, any discussions you may have or wish to have can be discussed around the table at the meeting. As a consequence, there are no secrets or surprises, which is the basic premise of the process. However, if you do wish to have something discussed privately, that would need to be shared when you all get together around the table. So that is actively not encouraged. The whole point of the collaborative process is to have it all around the table. But if anything needs to be discussed, it needs to be shared openly.
Okay, so how many meetings would there be in total?
Okay, well, again, this very much depends on each family or case by case basis, and depends on the type of issues that needs to be resolved. Usually speaking, there are about 3 or 4 meetings before matters are then completed and hopefully settled. Before each meeting, an agenda is agreed and shared to ensure good progress is made at each meeting, so each party knows what's going to be discussed and so forth. And this also very much helps to focus the meeting and ensure that time is well spent.
Fantastic. Our next question today, Mailing, is are all cases suitable for the collaborative process?
Now, collaborative law is useful in a wide variety of cases, but sadly, it's not appropriate or possible for every single case. Your collaboratively trained lawyer will discuss with you your individual situation and circumstance and will guide you as to whether this process is right for you and your family. Um, for instance, if there has been, issues of domestic abuse in the past, or where there is sort of little trust between the respective clients, then it may be that the collaborative lawyer will advise that the process is not right for you. So it's best to be guided by them.
Excellent. And our last question today for you, Mei-Ling, is if I get completely fed up with the process, can I just go to court?
Now, at the outset of the collaborative process, so each client will be invited to enter into something that's known as a participation agreement. Okay, this is like a contract to ensure that the principles of the collaborative process are followed. For instance, the obligation to negotiate in good faith, and unless you end the process, not to pursue the court route. So this is really to ensure that each person is committed to the collaborative law route and gives it their all. However, sometimes the process just doesn't work despite best efforts on both sides. And in those cases, you are able to make an application to the court, or one side is able to do so. Now, where that were to be done, each side would then need to dispense the services of their current lawyer and instruct new lawyers. And again, this is something that is clearly set out in the participation agreement. So in short, the same lawyers are not able to act in court proceedings. And I suppose the benefit of that is that this is further incentive for each client to try to make the collaborative process work.
Fantastic, Mei-Ling. It's been an absolute pleasure having you on Fact Friday. I hope it's lived up to your expectation. And if anyone has any questions at all, please do pop them in the comment section below or get in touch with Mei-Ling or myself. And I hope to see you all soon. Take care.
Thank you very much.